Good morning. I'm Inspector Michael Brown. I'm the Mental Health Coordinator for the College of Policing. This is just a short, very informal, very casual video to explain the changes that are coming up to the Mental Health Act on the 11th of December 2017. Policing and Crime Act of 2017 amends the powers that the police have under the Mental Health Act, and it's going to have some implications for frontline police officers and perhaps a few more implications for National Health Service staff. So this short video is just to go through not every single aspect of the changes, but the main ones that are going to affect frontline operational staff. So very firstly, the scope of Section 136 of the Mental Health Act is going to expand. The definition of where this power can be used in the future will be that it can be used anywhere other than a house, a flat or a room where the person subject to the decision lives or where anyone else lives. So, for example, someone can't be detained in their own home, nor could they be detained in the house of a friend or a relative or a neighbour, assuming that they're in that dwelling with permission. Nor can they be detained in any garden, garage, yard or outhouse that is associated with that dwelling, assuming that it's not a communal facility. So if someone has a garden at the front of their own house or at the front of their relative's house, they can't be detained in that garden, they can't be detained in the garage. But if somebody lives in a block of flats, for example, where there are potentially 20, 30 different dwellings and there's a shared space at the back of the premises that's used as a garden, then Section 136 could be used in the communal garden. So the scope of the power is going to widen, which can be used in slightly more places. The main thing to remember is you cannot use Section 136 in a dwelling. Secondly, once officers are at an incident where they're considering the use of Section 136, there is now a requirement in law that officers must, where practicable, consult with either a doctor, a nurse, an AMP, a paramedic or an occupational therapist. Now, there's no specific obligation for the NHS to set up a consultation mechanism to allow this discussion to take place. So it very much will rely on whether there are local street triage teams, local crisis teams who are willing and able to take a phone call from the police or to take some kind of consultation and discussion with the police. And if they're not, that's fine. It just simply means that under law it is not practicable, and therefore the officers are allowed to make their decision without reference to any of the professionals that I've just listed. Once a police officer has used the power, there is then a decision to be made about where we will take the person as a place of safety under the Act. So the definition of a place of safety is only slightly different from what was before, and it now states that a place of safety is residential accommodation owned by the local social services authority. If we're honest, in history that hasn't really ever been identified or used as a place of safety, but it is still there in the definition. And the other three aspects of the definition are, the bits that everyone will remember. It is a hospital, a police station, or any other suitable place. There's now a new subsection into Section 135 which helps us understand what any other suitable place means. So if we are considering taking somebody to a location that is not a hospital or not a police station, any other suitable place means that you could, for example, remove someone to their own home or to the home of a friend or family member. If you're going to do that, you need permissions. You need agreement by the person who has been detained, and if you're taking them to any location where someone else also lives, you need the permission of one person who lives at that location. So for example, if I was detained under the Mental Health Act excuse me, I do have a cough. If I was detained under the Mental Health Act, I could be removed to my own home address, but my wife would also need to give agreement. If a person who lived on their own was proposing to be taken to their own home address, only they would need to give their agreement. Any other suitable place could also be a non-residential setting. In history, for example, we know that on one occasion a headmistress's office in a school was used as a place of safety. Also, a GP surgery was used as a place of safety. About 10 years ago, my response team even dealt with an incident where a lady had left a maternity unit whilst mentally unwell, having just given birth, and the agreement was very much made that if we used 136, we could take her to the maternity unit as a place of safety. Now, all of these places would not typically be listed in a local place of safety protocol. They're unlikely to be something you would agree to do on a regular basis, but in very case-specific circumstances, as all three of those were, nothing prevents a consideration about whether to improvise through a solution where we're using places not listed in local protocols. This would need to be very carefully done. You'd have to liaise with the AMP who's going to have to do the assessment. You'd obviously have to have the permission of whoever controls the school or the GP surgery or whatever location it is that you're proposing to use. But the typical two places are always going to be hospitals or police stations, because either somebody will get removed to A&E because of the fact they have a physical injury or illness in addition to their potential mental illness, or we will be using a mental health unit place of safety, which is where the vast majority of people will be taken. Usually this is a distinct, safe, calm, quiet room in a mental health unit or adjacent to a mental health unit where somebody can be taken in order to be safe until they're assessed by an AMP and a doctor. Police stations are now subject to some new regulations. We have the Mental Health Place of Safety Regulations 2017. Two things to say from there. Firstly, a police station can now only ever be used as a place of safety if three criteria are satisfied. Firstly, the detaining officer who's made the decision to take someone to a place of safety must be able to confirm that they think the person's behaviour poses an imminent risk of serious injury or death, either to themselves or to another. Also, the officer must reasonably believe that no NHS or established place of safety location would be in a position to manage the risk. And finally, the decision to use a police station must also be authorised by an officer not below the rank of inspector. So in the real world, if a constable has made the decision to detain somebody, the situation is quite a difficult and dynamic one. Restraint is being used, there is aggression or fear or violence being offered in whatever proportions. The officer would have to think this person's at serious risk of, an imminent risk of serious injury or death. I don't think the NHS or an A&E department will be able to handle this person. Will the duty inspector authorise this? Now, for the officers and for the inspectors who might have to authorise this, I've got a couple of things to say which are very, very important about mitigating the risk that we end up with a very serious untoward outcome, such as a death in police custody, especially if restraint has been used. What I would say there is, first and foremost, regardless of where we go, if somebody is posing an imminent risk of serious injury or death, get an ambulance involved if you possibly can. This is for lots of reasons. It can be because agitated, aggressive behaviours can be symptomatic of lots of things, not just mental illness. It might be handy to have a paramedic there to help try and guide that decision about where we take somebody as carefully as possible. Secondly, there are guidelines within the NHS and patient safety alerts that have been issued by the NHS which do talk about the clinical risks to individuals if they're exhibiting fearful or even aggressive or violent behaviours, because of the fact this will typically attract a restraint, whether it's by police officers or in any other context, and that might mean that they need to give consideration to those guidelines which relate to the management of violence. This can include that it is sometimes necessary to go to an A&E department. Obviously that's going to be a very difficult task to undertake, because an A&E department is not a secure setting that's set up for the purposes of receiving people who are presenting in very challenging ways. So it's going to be, if this is the location that we're going to go to, it's going to be very necessary for police officers to make sure that they are there in sufficient numbers to firstly prevent NHS staff from being assaulted, and secondly to prevent the person who's been taken to A&E from taking a decision to leave. So this